A flurry of court decisions in just a few days has many issued without argument or explanation. Here to help us make sense of it all, I'm joined by Dr. Courtney Barclay, Associate Dean of Academic and Faculty Affairs at Jacksonville University. Good morning.
Good morning.
We're also joined by Bryan Gowdy, appellate attorney at Creed Gowdy. Thanks so much for being here again.
Good morning.
All right. So I'm going to start with you, Bryan. There were so many consequential decisions this term, and we'll kind of get to a bunch of them. But I'm curious just kind of what your main takeaways were from the Supreme Court session.
Sure. The main takeaway I would say is increased presidential power and decreased power for the lower courts, the administrative agencies, and Congress. That's sort of the overall trend, and we can go into specific examples. But clearly, I think it's very fair to say that the power of the president is growing, and the power of the lower courts to restrict that is being diminished, as is the power of any sort of independent administrative agencies.
Dr. Barclay, do you consider those changes seismic or just sort of incremental? And in terms of the history of the court, how quickly does it typically move in one direction or the other when it comes to changing the balance of power?
So historically, looking at how quickly things change really depends on the makeup of the court. What's interesting here is we've had a fairly stable court for many years. When we look at Justice Roberts coming in as Chief Justice 20 years ago, we had a really long period of time where we had stability on the court as far as membership goes. So as you see new members come on, it changes the balance of the court. I think the changes that Bryan is talking about are notable because they're happening so quickly with increased cases coming out of the administration, asking those kinds of questions at a rate that we haven't seen before.
And so one of the things in terms of the requests coming from this administration are emergency requests. These are, requests for, it's sometimes called the shadow docket. And I'm going to ask you to explain it a little more, but basically these are decisions that the court makes without hearing argument. Is that right?
For the most part, they have tried to have some arguments on the emergency docket or shadow docket, whatever term you prefer. But for the most part, they're done without oral argument, and they're cases that are still pending in the lower courts, which are still being litigated in the lower courts. And there's been some type of preliminary or preliminary injunction generally that's been entered, and the party who's enjoined, normally almost always the administration these days, is asking the Supreme Court to stay that preliminary injunction on a very expedited basis. And often, for you brought up the Education Department decision that came out, I think, 2 days ago. These are being done not only without oral argument, but without any opinion from the majority. And we really only can understand what's going on if one of the dissenters writes an opinion, or we have to go and look at the court documents that were filed. But a lot of these, we not only no argument, but no opinion from the court.
And it's interesting your point. And, there was 2 mass firing decisions made by this court on this emergency docket this term. One was this recent decision allowing the Department of Education to lay off as many as 1,400 employees. And as you say, there's no majority opinion from the court. They didn't offer any explanation, but the Justice Sonia Sotomayor wrote a dissent, and she basically said that this would unleash untold harm on the community. But that is really, Courtney, the only window that we're getting into kind of what justices might be thinking.
That's right. In both of the cases that you mentioned, the dissents are many pages long and give us a lot of detail, much of it drawn from the lower courts that are being overturned. And I think in that case in particular, Justice Sotomayor was referencing the fact that if we stay the injunction and allow these mass firings to go forward, you're basically allowing the administration to fire people who are necessary to carry out duties that Congress put in place.
And we should say the point of an injunction is to sort of hold harmless as much as possible, either side, so that there is an opportunity for the court to move at pace or for the issue to be heard in lower courts without causing irreparable harm to one side or the other.
That's right. In most of these cases that the Supreme Court has issued a stay in those injunctions, the injunctions were put in place to maintain the status quo, not to make a change.
Okay. Well, let's, if we can, kind of get into the decision, which was one of the major decisions about birthright citizenship, that didn't actually make a decision about birthright citizenship, which has long been believed to be kind of a constitutional right, or an element of an amended constitution. But it has to do now more with the lower courts and what they can or can't do. Um, let's start, if we can, by just listening to a little bit of what the president had to say after this decision was announced.
Our country should be very proud of the Supreme Court today. Thanks for this decision, and thanks to this decision, we can now promptly file to proceed with numerous policies that have been wrongly enjoined on a nationwide basis. And some of the cases we're talking about would be ending birthright citizenship, which now comes to the fore. That was meant for the babies of slaves. It wasn't meant for people trying to scam the system and come into the country on a vacation.
So the birthright citizenship case will proceed, but can you explain to us a little bit about how this decision changes the power of lower courts, of federal courts?
Yeah. So the term of art is called a universal injunction, and essentially you'll have a party come to the court and say that, and this isn't just the Trump administration. This is going back several administrations. Parties will come to the court and say that some administration policy, or it could even be some other entity's policy, violates the law, and that the administration should be stopped from carrying out that policy or carrying out that practice, and have it apply universally to everyone who's impacted by that policy. And the court, in the case's term, decided that there was not authority under the Judiciary Act of 1789 for lower courts to issue those type of universal injunctions. And so what that means is that the courts can still protect the individual parties before the court. It makes it more difficult to get relief for everybody impacted by the order. Though I would disagree with President Trump. He's already been proven wrong. A New Hampshire court has already issued a nationwide injunction against the birthright citizenship order using a class action mechanism, which the Supreme Court, in its opinion, and Justice Kavanaugh talked about, I believe, in a concurrence, said would be an appropriate method to do it. So I think he's overstated his win on this, because it's already been enjoined again. It's just been done through a different procedure.
A different venue, right. But this is interesting, Dr. Barclay, because, birthright citizenship is something that has been litigated and has generally been interpreted to mean that children born in the United States are, by virtue of being born here, U.S. citizens. And the administration wants to overturn that. It's my understanding that typically when some court issues an injunction and says this is, this cannot be enforced because it is illegal, they're sort of relying on the likelihood that you're going to be successful as a litigant. So that they say, like, we're going to keep the status quo because it's unlikely that this change is going to be successful. And in this case, does it not matter that the issue of birthright citizenship has already been decided and decided again, when the Supreme Court's looking at this and essentially saying we're going to allow this change to happen?
I think that is what the Supreme Court said with this decision. Now, they did not decide the case on the merits, so they left that open, that they would likely see more cases percolating up to the Supreme Court on the actual merits of the executive order and changes proposed to the birthright citizenship. But this seems to be one of the examples where universal injunction is exactly what it was intended to do, an executive action or a law that is so patently unlawful. And it violates not only constitutional, but also statutory law as well.
Yeah. If you're just joining us, we are talking about some of the consequential decisions of the Supreme Court term. We are talking to Bryan Gowdy and Dr. Courtney Barclay, and you are welcome to join our conversation. Give us a call at 904-549-2937. You can email us at firstcoastconnect@wjct.org, or you can reach out on Facebook, Instagram, or Twitter at FCC On Air with questions or comments. So in addition to this one major decision, obviously there was, a lot of others, but I'm curious, do you think that this is chastening, Brian, to lower courts? What does it make? I mean, you're in federal court all the time. You do a lot of appellate work. They also seem to be sort of skipping over the relevance of the appellate courts in terms of, their power. Do you think that this is is it an insult, for lack of a better word? Are they disregarding the work of these lower courts that have issued long opinions and done a lot of research that they're essentially not taking into account?
Yeah, I don't know if I'd go so far as an insult, but I mean, just for example, Justice Jackson, in one of her dissents to this, in one of the recent emergency docket ones, she really called the majority to task because the lower courts are charged with making findings of fact. That's not something that an appellate court is equipped to do, because in the lower courts, the federal district courts is where you see sort of what you would see on TV, where you might have witnesses called and people testify and things like that. You don't see that in the Supreme Court or the appellate court. And so um, her dissent forcefully makes the point that the Supreme Court is overstepping its bounds because there is this division of power between the lower courts and the Supreme Court in what they do.
I mean,
Uh,
lower courts are hearing facts and making decisions about the facts in the case, and they're also making judgments about the credibility of either witnesses or attorneys presenting the case.
right.
And that too is something that the Supreme Court is in these decisions
Yeah.
not taking into account.
Well, yeah, I wouldn't say they aren't taking it into account, but there's certainly strong arguments that they aren't giving the normal deference that they used to give. I would just say on the flip side, the criticism of these universal injunctions has been that it allows a single judge, and we have I don't remember the exact number, but hundreds of federal district judges in this country, and it allows a single judge to stop a policy nationwide. And so I think that's what the court was trying to get at, but there are certainly other problems with their ruling. And I would just add one thing too is the court did not rule that these universal injunctions were unconstitutional. They interpreted a very old statute. Congress could come in and fix this. At least arguably, there are people that are arguing universal injunctions are unconstitutional, but the court didn't reach that. And as I mentioned before, there's a device called a class action that allows essentially the same thing. And I've done class action work.
But it
And
does require every single party to kind of come and
well, there's certain obstacles to get a class action. You have to prove certain things. I won't go through them to bore your audience. It's more difficult to establish a class action than it is to get a universal injunction. But again, Congress could change those requirements. They could make it easier to get a class action. So I guess, I think I would just point out that yes, the court has made it more difficult for lower courts to enforce the Constitution in some regard. But Congress could fix it. And the last thing I just add, I think it's very odd. The universal injunctions, there's been a lot of complaints by presidential administrations of both parties about universal injunctions because they also, they get applied to the Biden administration.
right.
And so I just found it odd that they decided this particular case to deal with it, the birthright citizenship case, because and Justice Sotomayor made it, a very forceful dissent. She did address the merits, unlike the majority, and there's no court that's agreed with the administration that President Trump's executive order is constitutional. It's a very strained reading, I think, of the 14th Amendment that is novel in some circles, but hasn't been accepted by the courts. And so, this was not the case, in my view, that you wanted to trim back universal injunctions, but it is the case the court took up to do that.
We have a call from Denise in Mayport. Good morning, Denise. Go ahead.
Hi, please ask your guests to comment on the possibility that the reason this conservative wing of the Supreme Court agrees with everything Trump wants to do isn't just because they like him or they owe him for their job, but they also understand that he would thumb their nose at them if they told him no, and that the Supreme Court really has no enforcement mechanism. So I think they're more afraid that Trump will pull back the curtain and expose them for the Wizard of Oz that they are if they tell him no. How much do you think that factors into some of their willingness to give him so much power? Thanks.
That's a very good question. Of course, it's a branch of government that doesn't have any law enforcement arm or any, military might behind them.
Yeah, I mean, your listener's absolutely correct. As you said, the Supreme Court relies on the other branches, particularly the executive, to enforce their decisions. I wouldn't go so far as to say that that is a dominant factor in their decision making. And I think the proof of that is that the Supreme Court has said no to President Trump. When we're looking at the emergency docket or the shadow docket that we've been talking about, the Trump administration has overwhelmingly seen success on those. But when we look at the merit docket, there are areas where the Supreme Court has said no. And I think even in the emergency docket decisions, the Trump v. Casa, for example, that we've been talking about with birthright citizenship, I think Justice Barrett's opinion sort of lays some doubt as to whether the Supreme Court would find for the administration when they review that on the merits.
I mean, doesn't that speak to sort of, though, the need to hear these cases and to make a decision based on the merits as opposed to an emergency docket type order?
Absolutely. And I think that's one of the changes that we've seen is emergency docket is not a new phenomenon. It's been in existence since almost the birth of the Supreme Court. But what we have seen is an increased use of this for complex issues and administrative actions.
We also have a call from Kendra in Mandarin. Good morning, Kendra. Go ahead.
Good morning, Anne. Thank you for taking my call.
Sure.
Well, I think that it's pretty clear that we are well within the attempted overthrow of our democracy as we know it. I think that President Trump and also Governor DeSantis are using very classic techniques that are always seen with the rise of authoritarian regimes. These include firing and eradicating experts and leaders in knowledge, eradicating the flow of information, such as with the pooling of funds for public broadcasting. And the overall effect is that we're becoming weaker and less knowledgeable with less access to information. That is extremely beneficial for an authoritarian regime because they can simultaneously manipulate and fabricate facts. So this is very detrimental to democracy and to the people overall, while it's benefiting that billionaire class and those who wish to benefit at the taxpayer's expense. Thank you.
Thanks, Kendra. We appreciate your comments. This is something actually that the Justice Jackson, Ketanji Brown Jackson, spoke about during an appearance last week. She was being interviewed about a memoir that she has out, but she did talk about her concerns about some of the issues that have come before the Supreme Court. Let's take a listen to that.
What keeps you up at night?
I would say the state of our democracy. I would say that I am really very interested in getting people to focus and to invest and to pay attention to what is happening in our country and in our government.
Bryan Gowdy, how unusual is it to hear a Supreme Court justice make an assertion that strong about I fear for our democracy?
It is unusual, and it's not just she's not just saying it in her public remarks. She's saying it in some of her opinions. For example, in the case we talked about earlier dealing with birthright citizenship, she said it in her dissent. the court's decision to permit the executive to violate the Constitution with respect to anyone who is not yet sued is an existential threat to the rule of law. It's pretty strong language.
Mm.
And there's also been some very strong language in these dissents that the majority in one opinion called provocative. For example, in a case dealing with the removal of immigrants to South Sudan, where they were not from, Justice Sotomayor documented how the government had not followed court orders and then said in conclusion, given its conduct in these proceedings, the government's posture resembles that of the arsonist who calls 911 to report firefighters for violating a local noise ordinance because the government was complaining about the district judge violating certain rules. She said, if we want to look who's not following the rules, it's you. So, yeah, it's very strong language. I don't think I've seen this. I don't think I would have seen this, 10, 15 years ago in court opinions.
I'm going to have you just scooch a little closer to the microphone,
Oh,
Bryan. Thank you. I
sorry.
appreciate that. No, that's okay. So she's not just discussing the future of the democracy or criticizing even the administration, though. She's criticizing the court. And in a recent decision where the court basically agreed to allow Doge to access Social Security records, she wrote a very biting dissent where she said that once again, this court dons its emergency responder gear, rushes to the scene, and uses its equitable power to fan the flames rather than extinguish them. And so she's, really calling out her colleagues. And I'm curious if that is unique as you see it, because there was I thought, kind of a funny funny comment, Dr. Barclay in Politico recently, where they described it as possibly 9 people who are deeply divided over the law and the role of the courts, and who also may just not like each other very much.
I think that's not unique rhetoric. We saw the same thing with dissents and majority opinions between Justice Scalia and Justice Ginsburg. If you go back to the 1800s, you can see Justice Harlan, although the type of language they used in the 1800s might mask the rebukes a little bit better
Although
modern
we
reading.
know that Scalia and Ginsburg were actually pretty close, though, in
Yes.
real life, right? In real life. Anyway, I just kind of interject that they did have some, tough language in the decisions.
They did. I think, we also saw that Justice Scalia, I think it was in 2015, if my memory is serving me correctly, which probably it isn't. But, I think he likened Justice Breyer's reasoning to the writings of a fortune cookie. So
Yeah.
we have seen this kind of language. I think it is getting a little more intense. I think we're also seeing a personal reaction coming from the majority in a way that we haven't seen, at least not that pointedly. I think this goes back to the previous caller's question about sort of access to information and Justice Jackson's response that you played for a moment. And that is, the one benefit of this is that I think it is getting people more interested, not only in the Supreme Court sort of politics and who likes who and who's spending time with whose families, but what's going on and what are the decisions?
Could I just jump in on that?
Yes, please.
Yeah, so I agree that we've seen, certainly from Justice Scalia in the past, really sharp language. I recall there was an opinion where I think he called the majority's reasoning like, I would put a bag over my head or something like that. But I think this is different because it's actually saying, another quote, Justice Sotomayor calls this lawlessness.
Yeah.
And then she says other litigants mean not the government, must follow the rules, but the administration has the Supreme Court on speed dial. There's a lot of accusations in these dissents, and I will say they're not really coming from Justice Kagan so much. They're coming from Justice Sotomayor and Justice Jackson, basically saying that we're in a lawless state. I think even Justice Scalia, I don't think ever used language like that. I don't recall. So I think it, and the second thing I would just say is I don't think it's personal. I don't agree with that. I I don't think there's some personal animosity among the members of the court. I do think they actually do get along. I think they sharply disagree on things. I do think they sharply disagree civilly, even though they use sometimes difficult language. I'm getting more to the substance here, where you have justices calling out the government as acting lawlessly. That is, to me, new.
Yeah. This term seems to be kind of unending. I mean, most people understand the term to start the first Monday in October, usually sometime around, end of June, July, they begin a recess. And that is maybe going to be different because of this emergency docket and the use of it. I mean, are we going to just see a kind of a year-round Supreme Court set of decisions?
That certainly seems to be the case. And you're right. Normally, a lot of the sort of fanfare around Supreme Court decisions wraps up end of June. This year, we're continuing to see these issues get to the front pages, the top of our news feeds, because of that emergency docket. Again, it's not a new concept. The emergency docket has always run year round, but what we are seeing is those complex cases that normally would wait for a merits review during the normal term.
I'm curious what you think the Chief Justice, feels about the way this court is handling itself and also responding to the administration and these many requests for emergency decisions. Um, the reputation of the court is probably at a nadir. I mean, it is, one point viewed favorably by a majority of Americans, and now fewer than half have a favorable opinion of the Supreme Court. Is there reputational damage happening here?
Mm. The Chief Justice, I think, historically has been the most, we call an institutionalist on the court, concerned about the court's reputation as an institution. And at the same time, it seems like, at least this past term, he's not concerned about taking things on the emergency docket. I mean, it's amazing how many things are deciding on the emergency docket.
Mhm.
So I can't read what the Chief Justice is thinking this moment, but we can see on the emergency docket a lot of big issues being decided, as you said, without oral argument and often without an opinion. I mean, the Department of Education issue that was decided 2 days ago seems pretty significant to me.
And
And
to the dissent that we got from
well, right, but
Sotomayor.
there's no majority opinion. I mean, it's just a very brief blurb uh, staying the lower court's order. And in fairness, these cases do go back to the lower courts and will continue to be litigated.
But I guess
But the reality is that any order from the Supreme Court, even without any reasoning, has quite an impact on the lower courts.
it does. And I mean, the point of these injunctions is that the damage will be done. I mean, if they lay off as planned, 13 or 1,400 employees from the Department of Education, that is not an education department that can be restored, maybe, forever, possibly for a period of years, if in fact they happen. We do have a question I want to get to, though, before we wrap up. Andrew emailed, federal funding decisions, the power of the purse is constitutionally vested in Congress, not the executive. What then is the constitutional basis for the Supreme Court to allow the executive to unilaterally withdraw funding already apportioned congressionally for the Department of Education and USAID? Was there any legitimate basis, or are the justices just conservative ideologues? Dr. Barclay, your thoughts?
You want to go ahead?
I'll let you do either of you.
Oh, I would say that, actually, in one of these decisions dealing with the funding, even only Justice Jackson dissented. Justice Sotomayor did not.
That was
And
in the DOJ, basically allowing DOJ to fire across 19 federal agencies. That was
right,
an 8-1 decision.
and I think, like, you can be frustrated at the court, but you also ought to be frustrated at Congress, because Congress over the years has delegated more and more power to the executive branch, and there are parameters in which the executive branch can manage the branch and reorganize and terminate employees and things like that. And so the reason Justice Sotomayor concurred in that case was because the executive order said it was going to be done in accordance with law, and the specific plans weren't before the court. So it's not that the executive has no power over reorganizing its branch. It's the question of how much power. And then, on the Department of Education case, Justice Sotomayor did dissent because she felt like there they had gone beyond the power that Congress gave them. But I think a big problem is that Congress has really abdicated its constitutional responsibilities, and we could talk about tariffs, in that all these powers are vested in Congress, but yet they seem to want to just punt and allow the executive branch to decide things.
There
I
are
think
Go ahead.
I do think also the practical effect of these stays that you mentioned earlier, though, Brian, is really the pain point here, right? Because it's important to remember that as as the Supreme Court's deciding these applications for stay of injunction, they're not deciding the merits of the case. They're not saying that those actions are lawful. They're just staying an injunction, which, practically speaking, allows the administration to go forward with these plans sort of regardless of the lawfulness.
Right. And as you say, that'll impact things from people being deported to third countries. It'll impact tariffs. It's already impacting, healthcare for LGBTQ people. A lot of issues that we weren't able to get to today. There's so much to talk about, but we really appreciate you guys helping to tackle some of the issues from the Supreme Court term. Bryan Gowdy, Dr. Courtney Barclay, thank you so much for being here.
Thank you.
Appreciate it.
Thank you.